watching UNO with Dr. Ambrish Saxena.
Hello students, today is Tuesday 10th of December 2019 and this morning I welcome you all in 63rd episode of DME UNO. In Hyderabad, the rape and murder of a veterinary doctor and subsequently the arrest of the culprits and their killings in a allegedly fake encounter has rocked the country. Yesterday, I talked about the legal issues related to the encounter, which is said to be the fake encounter and extrajudicial killings. Today, I will try to discuss few more legal issues involved in the case. Yesterday, the Supreme Court and Telangana High Court, they took up the public interest litigations. Now, what is these public interest litigations? These litigations are in fact the petitions on issues of public importance, and these PILs can be filed in the Supreme Court under Article 32 of the Constitution and in any of the High Courts under Article 226 of the Constitution. In the Supreme Court, two PILs were filed. In the first PIL filed by Advocate M.L. Sharma, the Supreme Court was requested to institute a probe in this encounter by SIT under the supervision of a former Supreme Court judge. And in another PIL that was filed by G.S. Mani and Pradeep Kumar Yadav, the Supreme Court was requested to institute an inquiry to investigate the role of the police officers who were involved in the police encounter. The Supreme Court took up both the petitions and has fixed the date of 11th of December to further have a hearing on this issue. And in the PIL that was filed in Telangana High Court, the court was requested to institute an investigation in the whole case. And the court ordered the state government to preserve the bodies of the four accused till 13th of December. Earlier, the court had ordered for the preservation of bodies till 9th of December. The court has also decided to appoint an advocate, Prakash Reddy, as amicus curiae. Amicus curiae is in fact, the literal meaning is friend of the court. So, amicus curiae is in fact an officer who helps the court by way of providing the information or any expertise or any such material which is relevant to that particular case. Now, I must tell you about a very important case. This is PUCL versus State of Maharashtra 2014. In this case, the Supreme Court has set up certain guidelines, the total 16 guidelines in number, which are mandatory as far as investigation of a police encounter is concerned. And these guidelines have been ratified or endorsed by Supreme Court in many subsequent cases as well. This case was filed by People's Union for Civil Liberty, that is PUCL, which is an NGO, against the fake encounters in Maharashtra, wherein reportedly 90 people would have been killed in the encounter in Bombay alone during 1995 and 1998. Now, coming back to Hyderabad encounter, Telangana High Court has issued orders to the Advocate General of the state to provide details with regard to these Supreme Court guidelines and accordingly provide all that data which is related to registration of FIR against the police in this encounter. Now, the High Court will be hearing this case on 12th of December, since already the Supreme Court is taking up other PILs on 11th of December, and we can hope that within this week many more legal issues will be unfolded in this particular case. Now, moving on to another story. Yesterday in this program I talked about the Citizenship Amendment Bill 2019 and I refer to the exclusion of certain minorities in this particular bill. Now, as a follow-up story, I will further look into today in this program the aspect of constitutionality of this bill. And if I can tell you the details of this bill was taken up by Lok Sabha yesterday morning. The debate continued for the whole day for more than 7 hours. Around midnight the voting happened and this bill got passed by 311 versus 80 votes. This bill prescribes that all such refugees which are coming from Bangladesh, Pakistan and Afghanistan and who belong to 6 religions including Hindu, Sikh, Baudd, Jain, Parsis and Christians, they will be granted citizenship in India and the cutoff date is 31st of December 2014. This means anybody who would have come to India before this date will be granted the citizenship. But then during the debate yesterday in Parliament, the opposition members raised certain objections. They said that mixing religion with citizenship is in fact a violation of the basic structure of the Constitution. They also said that secularism has been mentioned as an important tenet of the preamble. So, by doing something based on religion, the preamble is in fact being violated. The other arguments, if we look into, the opposition members said that this bill has been brought in violation of Article 14. Article 14 is about equality before the law in all kind of cases. They also say that this is a violation of Article 15. Article 15 says that there should be no discrimination on the basis of religion, race, caste, sex or place of birth. The opposition members are also of the opinion that this is a violation of Article 21. Article 21 gives us the right to life and personal liberty. It is also said to be against Article 25 and 26. Article 25 gives us the freedom to profess, propagate and practice any religion. And Article 26 says that any religious institution can be managed by any citizen or by any group of citizens. The government says that there is nothing unconstitutional in this bill. The Home Minister said yesterday on the floor of the House that Article 14 does not forbid the reasonable classification as far as legislations are concerned. He also gave the example that in 1971 Bangladesh war, whosoever had come from Bangladesh, the Parliament had brought a legislation to grant citizenship to those people. The Home Minister also said that in other democratic countries of the world, these kind of reasonable classifications are done for the purpose of citizenship. He gave the example of the United States where the government had a policy with regard to granting the green card, that if anybody is making investment in the country or for research purposes or some other purposes, the citizenship can be granted. The Home Minister has also supported use of religion as a classifier. As we know that all these 3 countries, they are the Muslim majority country. So according to government, that if Muslims are in majority, so obviously no persecution of Muslims can happen. So that is how the government had justified this. And the final argument that has been made by the government, that under Article 11 of the Constitution, Parliament has the power to make legislation with regard to rules pertaining to citizenship. Now, after the passage of the bill in Lok Sabha yesterday, now Rajya Sabha is taking up this bill for debate, and we hope that many more aspects will be unfolded during the debate on this issue. That is all in today's edition.